The latest headline in the Hillary Clinton email scandal. She says the FBI has not reached out to talk to her yet. Roll tape.
No one has reached out to me yet, but last summer, I think last August, I made it clear I'm more than ready to talk to anybody, anytime. And I've encouraged all of, my assistants and to be very forthcoming, and I hope that this is close to being wrapped up.
So nobody said, Hillary Clinton, we'd like to sit down and talk to you from the FBI?
Not at this point.
Not at this point. Nobody's reached out. Judge Napolitano is here. What's that all about? What's it mean?
Well, I'm shaking my head because she is being misleading yet again. Has the FBI reached out to her directly? Absolutely, positively not. She's represented by counsel. The FBI would break all kinds of regulations if they reach out to her directly. Has the FBI reached out to her lawyer? Of course it has. This is the most crucial part of the representation of a white-collar criminal defendant. It's called pre-indictment advocacy. It's where your lawyer engages with the Justice Department and engages with the FBI to persuade them that your client is not the crook they think your client is. And he knows exactly when they want to speak to her, and it's within the next 2 weeks, and she knows that. So when you interview her, Mr. Varney, and you ask her, have you heard from the FBI? And she says no, I want you to follow up by saying, but your lawyers have.
Thank you. I think you put it in perspective. Right, North Carolina, the bathroom law. The bathroom law that they have says you go into the bathroom according to the gender that you had when you were born. Men to the men's room, women to the women's room. The Justice Department says that is a breach of your civil rights. Seems to me, hold on a second, seems to me a conflict of rights. The right of transgenders not to be offended by having to make that difficult choice, and the right of everybody else not to have to change the way they do their business after about 5,000 years.
I smile because, as far as I know, and all of my legal studies of the past 45 years, there is no right not to be offended. Wow, if there were, what a crazy world this would be. This has become a very complex situation, and there are strong arguments on both sides. It began in North Carolina when the city of Charlotte basically dictated to private property owners, restaurants and institutions like that, not just Charlotte city government, but private property owners, what kind of bathroom facilities they had to make available. Then the North Carolina legislature, for whatever reason, enacted its legislation. The stated purpose is to invalidate the Charlotte legislation so that private property owners could make their own choices. Then, as to what kind of bathroom facilities they want to make available. Then the federal government jumped in and said, this violates the principles of the Civil Rights Act. It doesn't actually violate the Civil Rights Act because, for reasons of compromise and accommodation, the Civil Rights Act does not protect. The Federal Civil Rights Act does not protect sexual orientation or sexual appearance. It does protect other things like gender, age, race, etc. So the Justice Department, which has threatened the state of North Carolina, will have to file a lawsuit and will have to prove that there are federal statutes being violated by a state law that says to private property owners, you decide how you want to manage your own property.
I can't believe we're discussing bathroom issues at this level.
Unfortunately, we are. I have seen
nonsense.
No evidence that if a transgendered person goes into a bathroom, they have harmed someone else of a different gender who is coming out of that bathroom. I think this is way blown out of proportion on both sides.
Thank you, Judge. I trust you will be back in the 11 o'clock hour.
Of course, if you'll have me.
Oh, we look forward to it. All right.